part 4 of the legal context lecture is getting at how do we prove discrimination, or in essence, how does someone who feels they were discriminated against prove their case. And it's important that we recognize two different kinds of discrimination. One is disparate treatment, the other one is adverse impact, and how those two need to be proven in a court through what we call the prima facie case. So disparate treatment, the person who is a victim needs to prove and make their prima facie case that there is discrimination against them specifically. And when there is adverse impact, which is when somebody is saying on behalf of women, on behalf of minorities, on behalf of men, there seems to be an adverse impact against this group of individuals. And then again, a prima facie case needs to be made, but that is typically made when we apply the 4/5 rule. So we'll get into specifically how to prove disparate treatment, how to prove adverse impact, and the requisite criteria for making a prima facie case. So starting with disparate treatment, well, we know that it is intentional discrimination against an individual for their membership in a protected class. So you can say, I'm going to treat you different because you're a man. I'm going to treat you different because you're a woman. I'm going to treat you different because of your religion, because of your ethnic origin, because of your accent, because you're married, because you're single, you name it. Those are all forms of sex discrimination. It can be direct, where somebody has a policy that says, I will not hire you. I worked for an organization where the boss said, I will never hire someone who is an Indian or Pakistani, which was against the law because he was discriminating against a group of individuals because of their ethnic origin. But nonetheless, that is what he did. So I didn't stay there too long after I found this information out. That was problematic. But it can be very direct, or it can be inferred. For example, you can use a pretext, and you can say, well, this individual shows up late for work, so therefore I am not going to, I'm not going to keep them on. I'm going to fire them. But what you don't know is, before, not long before this, they made a complaint for religious discrimination, for example, or sexual harassment. So the company turns around and goes, oh, look at that. You've been late to work for the last week, so we are going to fire you. In those sort of situations, the proximity of two events, it can be inferred that it is likely that the discrimination occurred because of a complaint somebody made, or because of an action that they took. They decided to join a union. Suddenly they get laid off. They were discriminated against because of their union membership, which you can't do either. So things can be very direct and very specific, or they can be very much inferred given the juxtaposition of two events or the proximity of two events occurring. So we want to be really careful about the context within which we are making some employment decisions, so that it is not inferred that we're using discriminatory information in order to make that hiring decision, because then it would be prohibited in that situation. So in terms of how do we infer that disparate treatment has occurred, how do we infer that someone was treating somebody differently because of their membership in a protected class? Well, here's the step, the prima facie case that the individual needs to make. That individual has to claim that they belong to a particular class that is protected from discrimination. It could be race, it could be gender, it could be religion, it could be ethnic origin, etc. That he or she applied for the job and was qualified for the job. So they have to make sure that the evidence was out there that they were qualified for the job. It shows up on a resume, it shows up on an application blank, that despite being qualified, they were rejected. The person doesn't have to prove that they were rejected because of the protected status, only that despite the qualifications, they were not looked at for whatever reason. After being rejected, the position remained open, and the employer continued to seek applicants whose qualifications were similar to those of the plaintiff. So very likely what will happen is that somebody else was hired after them that had poorer qualifications, or were at least the same as, if not poorer, than the applicant in the first place. So if they were the same as, and that the person who is claiming protected class status, for example, you hired a man, but I'm a woman and I had the same qualifications. Why didn't you hire me? Or, I'm black and that person that you hired was white and they had worse qualifications than I did, and yet you didn't even interview me. So once the plaintiff, the victim in this situation, makes this case, that's evidence that there is likely discrimination that occurred. And so then what happens is it has to go back to the courts, and you go back to the organization and say, look, the person made their prima facie case. Prove to us that you didn't use that criteria. Show us evidence that the criteria you used to hire the less qualified person or the qualified person, the equally qualified person who happened to be in a majority group, was a better candidate than the person that you rejected. Most of the time, if there is a really good reason, the organization can demonstrate it through whatever good documentation that they had. But if they didn't have good documentation, then it's really important for the organization to probably settle out of court before they have to go to court. So, if there's any chance that there may have been illegal criteria included, it is always in the organization's best interest to settle out of court, to make the case go away, so it doesn't show up as an issue, on their records. You certainly don't want that out as a public issue. But regardless, if you think that you've been discriminated against, it always helps to go to the EEOC. They review your case. They help you determine whether or not there is a prima facie case, and if so, they will tell you so, and then give you documentation to say, go ahead and sue. We think that there is a clear evidence here that there was discrimination. So inferring disparate treatment is not really that challenging. The goal is you need to have the evidence that you were rejected and then they kept looking, and that they were lesser qualified people that they hired in lieu of you for that particular position. So, as I was saying in the previous page, once the plaintiff makes their case, the burden then shifts to the employer to show that the discrimination is either the result of a bona fide occupational qualification, that it was necessary for the operation of the business, or the bottom line is the plaintiff is going to win. So, or they have to demonstrate that there is a reasonable reason why this individual was rejected, and it wasn't based on non-job related criteria. If the employer shows the discrimination is based on business necessity, the plaintiff then has the opportunity to show that the stated reason was false and merely a pretext. So you can say, well, in order for me to operate a safe business, I can't have a pregnant woman working in the office. Well, that's a pretext, really, for somebody who just doesn't want to have to pay, but doesn't want to have a pregnant woman around the office, because there's no reason why a woman who's pregnant couldn't work in an office job. So I know that's an extreme example, but it just gives you, evidence of what would be, how the response would be. In order to establish a case to go to court, the plaintiff need not prove that discrimination was a motivating factor, only raise the inference that the misconduct occurred. So making the prima facie case, making the inference that discrimination likely occurred here, in which case then, unless you have solid evidence that you have a bona fide occupational qualification, or it was reasonably necessary to do the job, or it was a business necessity, in the end, you're better off just settling out of court and making it go away, because your chances of winning in the courts would be pretty slim. So in terms of mixed motive cases for disparate treatment, this is this is based on the case Price Waterhouse versus Ann Hopkins, Waterhouse v. Hopkins. And in that situation, Ann Hopkins was not allowed to go up for partner. She was rejected for partner and not allowed to reapply, because they said, well, you're kind of gruff with customers and with staff. You're a little harsh. And you need to dress more femininely and act more femininely and speak more femininely in order to be considered a partner. So they had two reasons. They had a legitimate reason, which is, you're a little harsh, and they had an inappropriate reason, which is you have to act more feminine. Gender norm stereotypes are not defensible in the courts. That is considered a form of sex discrimination. And the same thing holds for men. Men are supposed to behave in a particular way. Men are not allowed to cry, or men are not allowed to show emotion. And so therefore, if you do, you start getting teased for it, or you get harassed for it, or you get told you are not acting enough like a man, so we won't keep you in this job. Same thing happens to women all the time, right? If we speak too firmly or assertively, we're told that we are too aggressive or too abusive or too harsh or too emotional, and so women get the same sort of situation. And those are based on gender norms and the stereotypes, and those are considered illegal. So a mixed motive case, the employer is accused of having both a legitimate or a reasonable reason and an illegal or illegitimate reason for making an employment decision. And of course, depending on the extent to which the statements may be considered offensive or a violation of the law, you really have to have sufficient evidence to show that it was, it might have had a substantive impact on the decision. So, but it is sufficient to just simply show that I'm in a protected class, and that appears to be the motivating factor for the decision. So in Ann Hopkins versus Price Waterhouse, when you say to somebody, in order to become a partner, you have to act more feminine. Well, there's no reason why someone has to be feminine in order to be able to be a partner in an accounting firm. And so there's no legitimate reason for someone to be more feminine to be able to do that job. So in that situation, you would want to make sure that you are not making an employment decision and including information like that in your employment decision. So even if there is a legal reason, like, oh, well, you don't show up on time, if you say, and you are, you're such a hysterical female and you never are, you're always in the bathroom crying, which may or may not be the case, those are sex role stereotypes or gender norm stereotypes, and therefore those would be considered illegal. The plaintiff only need to prove that the protected characteristic was a motivating factor or one of the reasons why. It doesn't have to be all the reasons. It just has to be a motivating factor, one of the reasons behind it, even if it's just a small role. But it needs to have legitimate impact, clearly. If the plaintiff satisfies the burden of proof that the discrimination was a motivating factor, the employer is found liable. So regardless of any legitimate reasons for not promoting or not hiring or having an adverse hiring decision, even if there's legitimate reasons for it, once you add one illegal or illegitimate reason, you taint the whole thing. So the burden of proof then really needs to shift to the employer to either eliminate or reduce the monetary damages by proving to the jury that they would have made the same decision in absence of the discriminatory motive. So they would have to say, well, regardless, we would still have made the same decision, even if we hadn't said that she needs to act more feminine or she needs to stop acting like a hysterical female, blah, 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 whatever that is. And you're never going to completely get rid of the discriminatory proof. It's just going to sort of minimize the financial damage to you, because once that's included in there and it's considered, legitimate, a legitimate complaint, then in the end, you're going to have to pay no matter what. So here's the lesson to be learned on mixed motive cases. You may have individuals who are discriminatory in the workplace. Who say, I would never hire a woman, or I'd never hire someone who's an Indian, or I'd never hire someone who's a Muslim, or whatever they might be. And those people are really problematic. We have to rein them in and we have to manage them well. So it's important that when your documented reasons for not hiring somebody are being laid out, you have to be particularly clear why this individual really is not appropriate for the job and have the support for that. Otherwise, you're going to end up with a discrimination case. And so it's always important to not have documented any evidence of anything that might even stink of a discriminatory procedure. It's always important to make sure everything is really clear, that it's based on job-related characteristics, that these things are not enough for that person to do the job. That the decision would have been made the same no matter what, and then you would proceed from there. So in terms of the differences about how a disparate treatment case or a mixed motive case is handled, under mixed motive, the burden of proof is on the defendant to prove that the decision would have been made regardless of the plaintiff's sex or race. Under disparate treatment, the burden of proof is on the plaintiff to make that prima facie case and say, you clearly made this decision, and you would not have made this decision except for my race or sex. So slightly different ruling, but it's the same basic idea. We have to demonstrate that with a mixed motive that regardless of my race or sex, the decision would still have been the same, and be able to make the case, for example, with Ann Hopkins versus Price Waterhouse. Is it possible that their assessment of her harshness with clients and her harshness with staffers might have been based on sex role norms, that a woman is not supposed to be firm and assertive, and that if she's firm and assertive, that is considered inappropriate or a form of sex discrimination if we say that she's too harsh. So again, we also have to look at the discrimination that's being charged and see if that influenced potentially the legitimate reasons that were also involved in there. Now we shift our attention to adverse impact as compared to disparate treatment. Remember, with disparate treatment, it's purposeful, it's intentional discrimination against an individual. With adverse impact, it is not intentional. It could be, but it is not necessarily intentional. So intent doesn't matter. You can have the best of intentions and still have an adverse impact against a group of individuals, which would mean that you would be liable for fixing and remedying the problem. So adverse impact is when an action has a disproportionate effect on a protected group, regardless of intention, which means that if I use a certain hiring criteria, men are more likely to be hired over women. It means you use the same criteria, but that men are at a better advantage for that criteria over women, and it's even when it's job related. So you have to find out if there is a better tool that you could use that would eliminate that disparate treatment. The only defense is really when you can justify it through business necessity or job relatedness, or if there's a bona fide occupational qualification. Business necessity, we can say that there's, in order for the safe function and effective function of our business, we need to do this. Or we can say, look, I get that this is a problem, but it is absolutely job related that people have this score, and it can be validated and it's appropriate, so they have to have this skill in order to be able to do it. Now, for example, firefighters, right? Firefighters need good upper body strength. They need to be able to carry a certain amount of weight in full equipment. And if women can't pass that exam, it doesn't matter. They would be, even if it looks like there's an adverse impact, if women can't do the job, then it doesn't matter. So the job relatedness is what's appropriate there, right? Assessment scores can't be altered or changed to reduce the impact on the protected groups. So you can't say, well, we have it validated, but we'll lower the score just to fix the problem. If your valid score says they need to have a 7 out of 10 in order to get the job, and you don't want to say, well, we'll make it a 6 so that we can make sure more women and minorities can get in the group. You can only change that if you find that the 7 is an unreasonable level of expectation. It can then be readjusted based on a new job analysis. And the job analysis or the validation of the skill set and what the level of skill needed can be lowered in order to, if it's appropriate. If you don't need to be a 7 and you really only need to be a 6, then that's perfectly fine. But if you absolutely need it to be a 7, you can't lower the score then just to say, well, this way we'll get more women and minorities. That won't work. Also, your assessment test results can't be ignored simply because they have an impact on a protected group. So you can't ignore it. You have to be checking this regularly. On a quarterly basis, you should be looking at your stats and your flow stats and your stock stats to make sure that you are in alignment so you have no surprises. If you're not regularly checking these statistics, then you've got some serious problems. And so it's really helpful if you could have your human resource information system set up in such a way that you keep track of this data, the flow, the stock statistics, and it could generate reports for you on a regular basis so that you can keep track of any problems you might be having with adverse impact in that situation. So one way that we can make our prima facie case for adverse impact is through stock statistics. And the stock statistics are comparing the percentage of women and men and minorities in a job category with their availability in the relevant population of qualified people who are interested in the position. Where do you get that information? Well, that usually comes out of the Bureau of Labor Statistics that keeps track of who has applied, who is looking for a job, and in your area, what general skill set that they have. Now, these are sort of broad categories, right? And they're making estimates based on skill set and jobs that people had previously. So, you're looking for representativeness of the qualified people in your organization relative to the qualified people in the population. So you need to be within 4/5 of the rate of those in your that are qualified in the workforce. So in this situation with clerical workers, it's turned on its head a little bit because women are more than represented. That's fine. There are significantly more women in your organization in clerical positions than there are in the relevant population. So there's no discrimination against women there, but is it possible there may be discrimination against men? And so one way that you would check this is to look at, you take 40% is the selection rate of people in the relevant population times 0.8, which is 80%, and that equals 32. So 32, 4/5 of 40% is 32. So your men in your organization, if men are complaining that they're not being hired for clerical positions, they could argue that there's an adverse impact against them in the workplace because your company only has about 20% of their clerical workers as male, yet there are 40% available in the local area labor market, but you're only hiring 20% of them. And even if you adjust it by the 4/5 rule to 32%, it's still greater than the percentage that you have in your company. So you may have a problem with adverse impact based on the representativeness of clerical workers in your organization, and not against women. It actually may be against men. And you may argue, well, men aren't really clamoring for clerical jobs, and that might very well be true. But what if there are men that are applying and are not getting hired? That's the concern that we have, and we would need to look at that to make sure that we are hiring representative work. So let's take it out of the category of clerical workers, which people would argue maybe men don't want jobs like that. Well, not all women want jobs like that either, but let's just set that aside and add a different category. What if it's a daycare worker where we expect more women to be attracted to that than men? And again, if men are looking for jobs in this area, but we're not hiring them for whatever reason, that could be the same situation, right? It's not just clerical work. It could be for any particular position, whether it's daycare worker or clerical worker or, marketing director or HR professional. Any of those positions could have similar issues. So be careful. Apply your 4/5 and make sure that you have representativeness of the stock from which you are pulling your employees, which is the number of the relevant population of qualified people in your local area. We also apply the 4/5 rule to flow statistics, which is the most common way that we apply the statistics. And basically what we're looking for is comparing the selection rate of our majority group to the selection rate of our minority group to make sure that even if we don't have a lot of applicants from a particular area, that we are hiring them at the same rate we're hiring the majority group. So there's some relationship, obviously, to the to what's available in the local market, but this is really specifically looking at the flow into the company then, not just whether or not we're representative, but if we have enough people applying, are we hiring them at a similar rate that we're hiring your majority group or the other group? So it could be, obviously it's not that we're always comparing men as the majority and women as a minority. It's what we're looking at is the number, the biggest group in my company. So if I have more women than men in this particular position, then the women are the majority and the men are the minority in this situation. So it changes based on the percentage that we have in our company. If you go back to the previous page where I looked at the stock statistics and that there were a greater percentage of women in clerical positions than men, we also need to make sure that the flow of men and the flow of women into the position relative to the number of applicants, the ones that are, once they apply, the rate at which they're being hired, if that's similar. So the same thing holds. And so if men are not being hired at the same rate as women for those clerical positions, we also have more evidence that there's problems. The Uniform Guidelines on Employee Selection Procedures, the UGESP, states organizations have to keep records of their flow statistics and selection rates. And they have to be calculated for each job category, for internal and external selection decisions, for every step in the selection process, and by applicant race and sex. So this is a detailed statistical analysis. You have to make sure you have it based on all the categories, whether or not it's an internal hiring decision or an external hiring decision, every step of the process, as they pass each selection tool to make sure each selection tool is not having an adverse impact. And so, again, making sure that we are being very detailed in this. This is where a good human resource information system setup is ideal because you would get it programmed so it would generate all those statistics for you. You wouldn't have to necessarily do the calculations yourself, but nonetheless, having a system in place to do that would be helpful. In our class, you're actually going to be engaging in some of these calculations all on your own. You won't have a human resource information system to do that for you. So part of your practice on measurement is going to be looking at some of those flow statistics and things like that. And just as a quick reminder, in the 4/5 rule, or the 80% rule as it's known, a selection rate for any race, sex, or ethnic group which is less than 4/5 or 80% of the rate for the group at the highest rate will generally be regarded as evidence of adverse impact, and this applies to flow statistics and stock statistics. It's only really a guideline, okay, because we also have to take into account small sample sizes and things like that. So it's a guideline, it's not a hard and fast rule, but if you have a sizable number of individuals who applied for jobs, and we clearly see over a 5-year period that there are significantly the rate that women are hired or that men are hired is less than other groups, then we certainly would have evidence to prove that there may be disparate treatment. Adverse impact going on, in the organization. The last category of statistics that we may need to use for proving adverse impact is concentration statistics. And again, what we're looking at is the percentage of men and women and minorities that are concentrated in certain job categories. For example, as they say here, if half of your employees are female, but 90% of those women are in the clerical workforce and they are not in positions that have any mobility or growth opportunities, they're pretty much at dead-end jobs, we may be facing a situation of adverse impact based on concentration statistics. The goal is that you don't want people to be underutilized in particular job categories. And so what we're doing with the concentration statistics is comparing the different job categories to making sure that women and men are properly represented in all different levels of positions in the company, that it's not just they're not just concentrated in a particular area. Because you could have majority women in some companies, but if they're all in clerical positions and they're not going to have any power or growth opportunities, that's discrimination, and particularly if women have the skill set and want to be able to move on. And the same thing turned on its head would be the same thing for men. If men are concentrated in a particular area but aren't given opportunities for growth, it would be the similar issue. And so there's some great examples there of just how people are concentrated in particular positions. For example, blacks are primarily concentrated in sales positions, Hispanics primarily concentrated in clerical positions, and whites are concentrated in management positions. And so you would want to have the percentages broken down there to be able to do your comparisons. So in terms of proving an adverse impact case, this is how it has to work. The plaintiff has to prove through statistical comparison, through stock statistics, flow statistics, or concentration statistics, that the challenged practice or selection device that is being used has a substantial adverse impact against a protected group. So the defendant can turn around and say the statistical analysis is wrong, or they can show different statistics, but basically speaking, it all comes down to the numbers that are used to be able to make the determination. So that's why clarity about who is an applicant and who is not an applicant, and what are appropriate job categories, what are not appropriate job categories for comparison's sake. We want to make sure we have that. If the plaintiff establishes disparate impact, or adverse impact as I like to call it, the employer must prove that the challenged practice is job related for the position in question and consistent with business necessity. So that means, for example, in the firefighter case, we saw a disproportionate number of women and minorities who were being rejected from firefighter positions. So the company has to then come back and say, I know that there are more women and minorities that are being rejected, but these are standards that we have set that are validated. We need to have these minimum characteristics or these minimum skill sets in order for someone to be an effective firefighter. And it has to be validated. And assuming that it's validated, then all you have to do is turn around and show that validation procedure, demonstrate that it is job related for the position. It's important to have it at this level. Then adverse impact doesn't matter. So if women and minorities are disproportionately affected, it's simply because they don't have the minimum skills to do the job, and not everybody has the ability to do every job. We have the right to apply for any job, but we don't always have the ability to do every job. So we have to be really careful about the difference. Adverse impact says everybody has the ability, has the right to apply for a job, but if you don't have the basic ability to do it, you're not owed that job, even if it has an adverse impact against your group. So even if the employer does prove business necessity, the plaintiff can still show, by showing that the employer maybe has refused to adopt an alternative practice that would meet the needs and not have an adverse impact. So what they're saying is, you can say that it has a business necessity or that this is required, but if there's an alternative tool that you can use that would not have an adverse impact, it would get at the same information, then you're obligated to try to use a different tool that does not have that same adverse impact. So these are things to be aware of.